All right, I think we'll get started. I know, just go ahead, get your coffee and whatever, and we'll get started here. I'd like to thank everybody for coming today. First, can you hear me in the back of the room? Am I projecting my voice loudly enough? A little more, okay. All right, thank you. First, I'd like to thank everyone for being here. My name's Keats Boyd. I'm the president of Boyd & Boyd PC. Whitney and I are the shareholders at Boyd & Boyd, so Whitney will be speaking during part of the presentation today. We're going to be talking about what do I do when a loved one dies, the basics of estate and trust settlement. Before we get into that, I just want to remind everybody what we do. We help families like yours protect the wealth that you have, employ strategies to increase your wealth, and pass a legacy that can last for generations. This is done through wealth planning and preservation. What that really does is it involves several disciplines: estate planning, asset protection planning, income tax planning, planning for retirement accounts, and legacy planning. So I just want to make sure that you're familiar with all of those. We talk about doing estate planning as our general theme. That's the term everybody knows, but I think we're doing a lot more than that when you look at some of these other disciplines. A couple of quick announcements. I know several of you have asked about our upcoming move. We expect to be moved in mid-October. We're going to be going over to Route 132, 1555 INO Road. We're going to be in what is presently the New York Life building. They are vacating some of the space. We're going to take some of that up and have a little more elbow room in our offices. We're excited about that move. We hope to have some form of an open house to invite everybody in once we have settled in and have the place looking presentable after our move. I think everybody knows Whitney and I, but just in case, we are the two shareholders at Boyd & Boyd. We also now have Matthew Goins as a team member. He joined us last Monday, and we're very excited to have him on the team. All of us are admitted to Massachusetts. Whitney also has a license to practice in the District of Columbia, and Matt also has his license in Ohio. Many of you know that over the last several seminars, we've been doing a little bit about cybersecurity. And I think something happened over the weekend. I was notified of a major data breach that impacts almost everybody in the United States. There was a firm, National Public Records or something to that effect. They basically had a data breach, and someone tried to sell 2.9 billion records on the dark web. They eventually made the database available for free. Now, this impacts almost all of us in this room. Now, you should do something to make sure that your personal information is protected, that someone doesn't try to open up accounts in your name. You can always reach out to the 3 major credit bureaus, ask them to put a freeze on your account so that nobody will be able to open up a credit application in your name. But you just remember that if you put that freeze on, if you do apply somewhere, you have to contact the credit bureaus to unfreeze, then put your application in, then replace the freeze. I think also it's a good idea to use something like LifeLock. They will monitor your credit, notify you if there is some form of application put in, and you can confirm that it is you, or have them help you to prevent that application from moving forward. They provide a fair amount of insurance, if you will. I think it's up to $3 million with one of the plans that they have, Ultimate Plus. We have teamed up with them to offer that. I was going to wrap this into one of our maintenance programs, but decided when I saw this that it's more important to put this out for everybody to know about. If you are interested, we've got the QR code. I can put this back up at the end of the talk this morning, but you can get a discount of about 29% if you pay annually. There is another plan that has a discount of about, I think it's 42% for families who are doing like husband and wife or couple planning for the household. You can do something like that if you want to do that. Take a look at it, see if you like it. I have to disclose, we do get a little commission on the side if you do decide to buy through our link. Don't feel like you need to do that, but I have to tell you that part of the way we've teamed up with them is for that purpose. but I think this is very good. It's something I have used for many, many years. I believe in the product. That's why I'm putting it out there. All right. Quick disclaimer, the information we're going to be giving today is intended to be educational in nature. It is not meant to be legal advice for your particular situation. While much of the techniques and approaches that we're going to be talking about in estate settlement will apply to many, many families, what you actually need to do when you pass away, or if you're helping a loved one who's passed away, that will vary from case to case. The type of assets that you have, how things are titled, all of that will impact what is needed to be done. So just understand that, and I hope that you get a lot of good information out of this. So first, why is an estate settlement necessary? Well, first, when you pass, we somehow have to transfer assets from you to whomever you wish to have receive your assets. You know, we have to look at the title. We have to look at beneficiary designations. We may have to look at statutes as well as your estate planning documents. All of these play a part in who's going to inherit from you. Before anybody can inherit, we have to pay your final expenses, any debts that you have, the funeral costs, the lawyer's fees, the estate taxes, the income taxes that you have for the year that you die. All of those must be paid first. The heirs cannot receive their inheritance until all of those expenses are paid. That can create a little bit of a delay. If everything goes really smoothly, if we're below the estate tax filing threshold, I'm sorry, I don't know what you're saying, Wendy. Once you've got those expenses paid, then we can distribute to everybody. We've got to do that in a timely fashion, and we want to make sure that we can distribute to the family members as quickly as possible. Sorry. You also have to file estate tax returns. If you're over the estate tax filing threshold, that's required. Massachusetts, the filing threshold is $2 million. Federally, the filing threshold is this year $13.61 million. Now, with the Tax Cuts and Jobs Act set to expire in 2026, that threshold will go down. We're estimating it to be somewhere between $6 and $7 million. That doesn't mean you shouldn't file anyway. Many families, we think it's a good idea to file even though you're not required. Massachusetts will not accept a filing below the threshold. They'll return it. But the feds will accept it, and there's a lot of good reasons why you should. Whitney will be talking about that a little bit later. We also have to address any income tax issues, filing your final returns. So, if you pass away, God forbid, in 2024, well, you've survived through at least August, you have income, and there's a tax return that needs to be filed. After that, maybe your trust will be filing a return. If there's a need for a probate, perhaps your probate estate will have to file a return. So there are going to be needs for some type of tax filing. And then we may need to plan for future taxes, meaning how can we minimize those taxes? Your plan hopefully will address some of that, but there may be a need to talk to, for example, your heirs. If they're inheriting your IRA directly from you, they have 10 years generally to take that money out of the retirement account. Maybe they want to do some tax planning to see when is the right time to take out larger amounts. If it's a traditional plan, they usually will have a minimum distribution they have to take out every year. But if they only take out the minimum distribution in the later years, or at least in year 10, when they have to close out the account, they could have a whopping tax. Usually right now that would mean they're going to be in the 37% federal bracket. In a couple of years, that bracket will become 39.6. Maybe it makes more sense to take some of that income out in earlier years to prevent that from happening so that we pay less in tax. Of course, there is post-mortem planning. What changes can be made to protect your family, to provide for less estate tax, to provide for less income tax? There may be a number of things, or maybe it's just a change in circumstance that when you did your original plan, we didn't know that one of the kids was going to be on Medicaid or SSI, and we need to alter the plan so that they don't lose their benefits. So we may need to be doing some things after the death to try to protect the assets and to protect the beneficiaries. So all of these are the reasons why we're going to do an estate settlement. How can an attorney help? Well, quite frankly, a lot of this stuff you are able to do by yourself. But the problem is you won't know about the traps for the unwary, the things that you can slip up on and not realize that maybe you just made a mistake. One of the biggest things we preach to our clients, and if you've heard me say this before, I apologize for repeating it. When somebody dies, call the funeral home, then call us. And I'm saying that half in jest, but seriously, what I'm worried about is that when the kids come to help you out as a surviving spouse, they often want to do stuff. And the intention is wonderful. It's laudable. I approve of the intention. The problem is, in doing stuff, we tend to not know the options we're missing. One of the big things, rolling over a retirement account. If you're the beneficiary of your spouse's IRA, 401k, 403b, and you just roll it over, you've missed the opportunity to say, no thanks, maybe I don't want some of it. Why would we want to say, no thanks, I don't want some of it? Because maybe if we've built the beneficiary designation right, like to an IRA inheritance trust, we can say no thanks, not only IRA, so it's out of our estate for estate tax purposes, but still available to be used by the surviving spouse. So we say no thanks, I don't want it, but we still get to use it. If we just roll over the IRA, it's too late. We can't undo that rollover. Another problem will be with life insurance, death benefits. Very often we have a spouse named as beneficiary. Sometimes it's better to say, no thanks, I don't want some or all of that life insurance. Because what are we doing? We're building up our estate. We're increasing the size of assets that we have, and we may be putting ourselves over the estate tax threshold. If we want to avoid that, we can say no thanks, and usually we'll want the trust to be the backup beneficiary. And even if it's not, even if it's the kids, sometimes it's a way of getting a gift down to the kids without a gift tax consequence. Remember, you're allowed to pass up to $18,000 in any one year to any one person. If your death benefit and your life insurance is, say, $100,000, and you say, no thanks, I don't want it, and it's going to go down to the kids, well, on theory, it looks like maybe you've given more than $18,000 to any one of the kids. But because it's a disclaimer, it doesn't count that way. And so we can get wealth down to the kids sometimes in a tax-efficient method. So just want you to know about these things. So please, before you act, wait until you can meet with us. Wait until we can go over what might be your options so you can get the best result for your family. It's not to say that you have to make a disclaimer. Just be educated that you have the option and that there are some things that maybe we can help you with before you start to act. So please, remind the kids that, wait, we want to talk with the attorney because there are some things that if we muck these up, we can't undo it. So the attorney is going to provide for guidance, structure, and timing. We want to oversee the administration of the estate to help talk about it. A little bit later, I'm going to talk about your attorney as kind of the conductor of the estate settlement symphony. They oversee the investment advisor, the life insurance agent, the tax issues with the accountant. We try to bring all these other disciplines together and make sure everybody is doing their part at the right time, with the right approach. Yes?
What is the time frame that you're constrained?
What's the time frame? I'm going to come to that a little bit later. We've got several different dates that are important triggers. We've got that in just a couple of minutes. Okay, so we can help with guidance, structure, and timing. An estate settlement really touches every aspect of your financial life, your asset bases. It can impact the lives of your survivors, And very often the family can be overwhelmed with the amount of work that there is to be done. I kiddingly tell some people, when we're here to help, you can do a lot of the work yourself and that'll help cut down on the legal fees, or you can have us do a lot more. You can kind of let us be, if you will, the scrubbing bubbles of estate settlement. Do you remember that old TV commercial, "We work hard so you don't have to"? That's kind of what we're trying to help some families with, and if that's what you would like, we're available to do it that way. If you'd prefer to do more yourselves and we kind of give you the guidance and here's the next step, we can do it that way too. Ultimately, we're going to do what works well for you and your family if you want to work with us. But we can tell you where do you start and what you need to do. We can provide that guidance to address issues and structure the settlement in any estate at any point in the process. Timing and the different deadlines, this is the answer to your question, becomes really important. A new deadline that we're super sensitive about is the Corporate Transparency Act. I've talked about this at a couple of our previous seminars. If you own an interest in a small business, you are likely impacted by the Corporate Transparency Act. You may be a silent investor, it may be a family firm that you've inherited from your parents or grandparents, and you still have some ownership interest. You may have filing requirements. You only have 30 days to notify FinCEN, which is the Treasury Department's Criminal Investigations Division. You have to notify them within 30 days of any change of a beneficial ownership. That means if you pass away with stock in a closely held business, the family has 30 days to notify FinCEN that you've died and somebody else is now the owner. Maybe it's your probate estate, maybe it's your trust, maybe it's paying on death, so it's going over to somebody else. You've got 30 days to deal with that change of ownership. And if you don't file that FinCEN report on time, it's a $500 a day fine for every day that your report is late. We also have valuation dates. These are 6 months from date of death. We first are going to get date of death valuation. That's our first one. So we can do that as soon as we have the information about what did you own. Sometimes that involves appraisals. Sometimes that involves using software to get your stock information. Some companies like Fidelity will do it right and they'll give us the information. It's not just the closing value, it's maybe the average of the high and the low for your stocks, ETFs, and your bonds. We need to get the right date of death value. We also have the ability to use alternate valuation, which means we can get another value 6 months after the date of death. We can use that if it's going to reduce any estate tax. So we might want to get a second snapshot. Now, alternate valuation is a two-headed coin. It reduces estate taxes, but it also reduces our cost basis. Sometimes getting a step up in basis and maybe paying a little more in estate tax is more important than reducing the estate tax because the capital gains we'll be saving might be more valuable. Depends on your particular situation. We have a 9-month deadline. That's for disclaimers. No thanks, I don't want something. We have to file that within 9 months of the date of death. We cannot have taken custody or control of the asset that we're trying to disclaim. Sometimes that means we only have a short period of time to make the disclaimer decision because we need to take custody and control of the asset. We also have 9 months from date of death to file and pay any estate tax that might be due. Once one disclaimer is made, if another beneficiary is going to inherit, let's say you disclaim and it's going to go to your kids. The person who is inheriting then has 9 months to make another disclaimer to get it down to their kids if they wanted to do that. So it's 9 months from the date that they learn that they've inherited something, which might be 9 months after you learn that you inherited as a surviving spouse. You make that disclaimer, then they have a 9-month clock to make another disclaimer. But we really want to get all of those disclaimers done before we file an estate tax return, which again is due 9 months from date of death. So while we have these long time frames, it could be as much as 18 months after date of death, we often need to compress them into a shorter period of time. Even though we have longer deadlines, we may need to make these decisions more rapidly.
Keith,
Yes.
on the 9 months tax return from the IRS, if you make a filing and then at some point in time later you find a change.
Right. So if you make an estate tax return filing and you find something's different, can you change the filing? Yes, you have to amend your return and file an amended estate tax return. So yes, you can do that. All right. Okay. So the next thing on the list here is September 30th after the date of the year, September 30th of the year after the date of death. So I die in 2024. We have to make a decision and understand who are the heirs of that retirement account no later than September 30th of 2025, the following year. We have to know who are the beneficiaries, who are the measuring lives, so that we can start taking minimum distributions the year after the death. In 2024, if I die this year, my minimum distribution is the one that needs to be taken, if I have one. That will still go to my beneficiaries, but the beneficiaries have to be determined by the following September 30th. So if I die in August, it's not, a month later, it's a year and a month later that we have to know that who's going to inherit. That can be a problem if you pass away and haven't taken your minimum distribution and we're late in the year. You pass away in September, you haven't taken your minimum distribution yet because you take it in November. We still have to know who the beneficiaries are before December 31 so that we can take the minimum distribution you are entitled to and give it to the right beneficiaries. So while we have until September 30 of the next year, we often have to take action long before that. Okay? October 31 is a date which, quite frankly, I have to admit, I don't remember what relates to that, but is a retirement account deadline. I would say that's oftentimes when you want to start taking your minimum distribution for any beneficiary. And that may not be why this is on the slide, but just as a point of interest, most institutions will say if you give them a request for a distribution after a certain deadline, they will not guarantee that you're going to get it before the end of the year. So usually it's a good idea to make sure you ask for that by, say, October 31 to give them plenty of time. Now, again, you pass away, we have to determine who the beneficiaries are. With an IRA trust, for example, or even if it's going right to the kids, we have to define your IRA and split it into separate parts for each of the kids before we can take their minimum distribution. So we've got to know who they are, we've got to get the paperwork all put together, and then we have to take your minimum distribution to get it to the right people. All right. December 31, again, you have to have your minimum distribution, and December 31 of the following year, the beneficiaries have to take their minimum distribution. No later than that. Most institutions say if you come to us after, say, December 15th, you're not going to get it on time. So you want to get ahead of that. Even though you've got a deadline of December 31st, you have to process your request. I'd say it's a good idea by October 31. If death occurs after October 31, it's hey, we got to get on the stick and do this right away. Yes?
During this lengthy period of time, how are you covering expenses?
How do you cover expenses for settling the estate? There's a couple of ways to do it. Usually your trust is going to be responsible for paying for estate settlement expenses. And when you pass away, a successor trustee is going to come on to own and manage your assets. We have to get them in place. They have to accept, sign some paperwork. We need to create a new certificate of trust, usually with a new tax ID number. That paperwork has to be submitted to the appropriate institution, the bank or other financial institution. And now they are on as a successor trustee. They can open up a bank account. They can start paying the bills. If we have a need to pay expenses beforehand, we don't have money to pay the funeral expenses. Usually what's going to happen is someone will front the money on their credit card, we do the paperwork, and we repay the person who lends, if you will, to the estate or to the trust for the necessary expenses. They're entitled to get reimbursed for that, okay? All right, so with oversight of acts, again, this is how your attorney can help you. Many individuals may need some assistance, and you're going to have a lot of different players involved. You've got your personal representative, what we used to call the executor or executrix. We can have a trustee. We can have surviving family members as named beneficiaries. You've got your accountant, your financial advisor, a whole slew of different parties that might be involved, and your attorney is going to oversee all of these different players. As I said, we kind of act as the symphony conductor, and this is a little AI image of a conductor there with their, well, not the metronome, what's the stick called? I don't know, whatever it is. Baton, thank you. The baton, yeah, that's, thank you ChatGPT for giving us that little image. But what this person does is they oversee all of the team members. You know, when it comes to an estate plan, you do have a team, whether you realize it or not. Our firm, as your estate planning attorney, we're part of the team, but you may have a financial advisor, you may have an accountant, you may have bankers, you might have a life insurance agent, you may have somebody who helps you with your annuities. All of those people are a part of the team, and we all need to work together, especially during an estate settlement. You may have separate specialists that focus on different issues, but, you know, like the accountant, they're going to focus on the income tax issue. Are we filing a complex trust income tax return, a simple trust tax return, or a grantor type trust? You know, we can tell them, hey, we wrote the trust, so it should be this way. It should be typically a grantor type trust now for most of us. But there are times where it's one of the others, and we just want to make sure that everybody's on the same page. They're going to focus on their specialty. We're going to focus on the big picture to make sure everything is moving smoothly and going along as rapidly as possible. Why is it necessary? Again, we've kind of been through this. We want to make sure that we've got all of these different things addressed, so I'm not going to repeat that. Review of ownership of all of the assets. When somebody passes away, one of the things you're going to get from us is a letter, and we've included something that should be in all of your binders. It's a little estate and trust administration newsletter. It was one of our early Beacon issues, and it really goes over the different things that need to be identified. Do you have bank accounts? Okay, gather up some statements. Do you have investment accounts? Gather up those statements. Same with retirement accounts. Do you have a life insurance policy? Well, let's find the policy. Do we have real estate? More than one piece of real estate. Let's get the current deed. Now, some of that we can find for you if you don't have access to that. Want to make sure we know where all the original documents are. We often will provide your will. We'll keep your will in our fireproof safe so that if something happens where you misplace the documents, we'll at least have the original will. We want to file that at the probate court. And if you lost your original will and we have to file a photocopy of it, we have to do a formal, long drawn out, the court oversees every step of the process. Ideally, we want to avoid a formal probate. So that's one of the reasons why we suggest you allow us to hold your will so that if it is misplaced, we'll at least know where it is. Okay, if you lost the rest of the documents, we have affidavit procedures to talk about a lost trust or a lost power of attorney, so we can work with many things through other methods. But we've got to identify everything that the decedent owned. We also want to identify how is it owned. Is it individually, jointly held? Is it in a trust? Does it have a beneficiary designation? If it's co-owners, is it tenant by common, meaning it goes through probate perhaps? So we want to look at all of these different things to see how the assets are owned, because how it's owned will determine what we need to do. We're really juggling a lot of different balls in the air. You know, you can have a bunch of assets, many of them might be in the trust, but your retirement accounts are still going to be individually owned, so we need to see what your beneficiary designation is. You might have a checking account. Is it individually owned? Does it have a pay on death designation? What does that mean for us from passing title to the next heir. And so we've got to look at all of these to decide what is the course of action to go from you to whomever it's supposed to end up with. We may have many different procedures we're going to follow because you may own assets in different ownership methods. So title will dramatically alter the terms of your trust, for example. If you have a bank account that's jointly held, it does not pass through your trust. It's going to pass to the co-owner. If you have an asset with a pay-on-death designation, it's going to go by the pay-on-death designation, not under the terms of your trust. We may lose the ability to use that asset as a part of an estate tax shelter that maybe we want to be able to use. So, titling things will make a big difference. As we've told you probably ad nauseum, best practice is to put almost everything into the trust. And of course, with every rule, there are exceptions. Do not put retirement accounts into the trust. Life insurance, if you're the owner, it does not need to go into the trust. Your day-to-day bank account, your checking account probably does not need to go in the trust, and your car generally is no real advantage to putting it in the trust. There may be a few other things we don't recommend, but as a general rule, everything else is probably a good candidate to be owned by your trust. So now we're going to start with the transfer of assets. We're going to look at the estate planning documents. Let's review the will. Let's review the trust. What are the terms and conditions? Who's supposed to inherit? All of these things are going to be governed by what you specified as we design your plan. Who's in charge and who's going to get it. Now, with a trust-based plan, your will is generally going to say, household goods, clothing, furniture, give that to my spouse if my spouse survives me, otherwise give it equally to the kids. Unless you say, oh, put this specific gift in there, then we'll do that as well. And then everything else should be given to your trust. And then your trust generally is going to say, for the benefit of my spouse, if my spouse survives me, they get income for life. They may have access to principal. They may be able to take income out if they need it. They may be able to get the principal if they need it for health, education, maintenance, and support. That's if we're doing tax planning. If we're keeping your trust revocable and it goes to the trust, well, then the spouse can do whatever they want. Okay? So we want to see who's in charge. Errors can cause unnecessary taxes. About maybe 10 years or so ago, we had a woman come to us. She had her plan drafted in Florida. Her husband had passed away. The lawyer in Florida said, put everything into a credit shelter trust until you hit the federal exemption, and anything over that put into a marital deduction trust. At the time, I want to say the federal exemption was around $2 or $3.5 million. So basically everything was going into the credit shelter trust. That meant in Massachusetts, she was going to have a very large estate tax due. The Florida attorney didn't remember that she had Massachusetts property while she was a Florida resident. There was Massachusetts real estate, and it triggered an estate tax by structuring the plan to say federal exemption is the only thing we look at. So it was a drafting mistake that cost that family about $60 grand in taxes they did not need to pay and could have totally avoided. Sometimes court intervention can correct those mistakes. So we can go to court to say, Judge, the goal of this was to avoid estate tax. Can you please allow us to modify the trust? All of the beneficiaries are agreeing, the trustee agrees, so let us modify the trust to build a Massachusetts credit shelter and a Massachusetts marital deduction so that we don't have that problem. Our documents also allow for 3 other ways, generally, to modify a trust after it becomes irrevocable. We can use decanting, we can use the trust protector maybe, and we might be able to do amendment by agreement. Now, amendment by agreement has to be built into your document. It is not something that Massachusetts law allows. When they passed our version of the quote-unquote uniform trust code, they took this provision out. It's in Florida, it's in California, and many of the other states that have some version of the Uniform Trust Code that if everybody agrees, they can just amend the trust. Massachusetts legislature in its great wisdom decided that no, we don't want to let them do that, make them go to court so they have to pay lawyers and court fees and all that other stuff. Well, we'd like to save you about $30,000, $40,000 of filing costs and attorney's fees by avoiding that, so we built in the way to amend if you want to, if everybody can agree, we can amend the trust by agreement. We just basically took the Uniform Trust Code provision and built that into your document. Now, if you've got our basic plan, you may not have, I'm sorry, I said the wrong one. If you have our simple trust, the low-end trust, that is the least expensive one we offer, that provision isn't in there. So we may want to look to make sure that you've got the right version of a trust. Maybe you want to upgrade to the basic version. It's a little more expensive. We can upgrade just for the difference, but you want to have that provision just to give that flexibility. Our estate tax is addressed. I've already talked about that a little bit. And then we want to identify the heirs and beneficiaries and the amount of an inheritance. If you give a specific gift, we want to know about that. And usually we want to get that off the table, give that away as soon as possible. But we have to pay debts and expenses and taxes first. But that might be one of the first things we do because we don't want to have that person approve accountings and be a part of it and maybe object to things and, hey, I want to know all sorts of information. Sometimes we build those specific gifts into the will. Even though we don't want to have a probate, if you've got a problem heir that you want to give a token gift to, maybe just enough to say, all right, I'll take that and I won't try to fight or argue or litigate, we'll put that into a will and not in the trust because we don't want that beneficiary to be able to get information about what does the trust own, how much is there, what's everybody else getting. That's none of their business. We'll put it into the will and try to make it so that if they contest anything, they could lose that gift, whether they contest the will, contest the trust. It makes it a little more of a more difficult thing for them and provides a little bit of protection for you to still give some token gift to somebody that you think might be a problem. We also want to review the estate plan of the surviving spouse and sometimes of the kids as well if they want that. But we want to make sure that if the decedent is the fiduciary, your executor, your personal representative, your power of attorney, your healthcare agent, we may need to update some of your documents if you're the surviving spouse to say, well, now let's change the pecking order. The person who was the backup, maybe they should be brought up to be the primary choice for your executor, personal representative. Backup becomes your primary person for your healthcare proxy, all of those things. So it's a good opportunity to review and then also to look at, gee, now that we have an idea of what you as the surviving spouse will own and inherit, what are we going to shelter from estate taxes? Do you still have an estate tax problem? We may want to do something to try to minimize that tax issue. The estate representative, all right, so if you're named as the personal representative or you're named as a successor trustee, you can be personally liable, like to the IRS. If you give away all the money and somebody comes back and says, wait a sec, we're still owed something, you can be personally liable because you're giving it away too quickly. This is why we want you to always keep some form of a reserve just in case. We want to make sure that you personally are not going to be on the hook for paying somebody else's share of a bill. The hospital doesn't send its bill out until, 10 months after date of death, and at 6 months you give everybody their money. Well, now you're personally responsible for that bill. Well, we don't want that. Could try to chase your family members down to say, hey, please return X amount of money. We'll often have them sign a release and refunding agreement, a promise to pay you back if it's needed, but we don't want to go there if we don't have to, because they may have spent their inheritance and you may never get that money back. So we want to make sure that you're protected, and this is where we can help to make sure that you are covered. We've got to make sure with estate taxes that we know what the assets are, what's subject to tax, they're valued properly. We want to file on time to avoid and pay on time to avoid penalties and interest. We want to deal with income taxes to make sure there are proper withdrawals from retirement accounts so that we're not subject to the penalty tax. Now, the Secure Act 2.0 changed that penalty from a 50% penalty to a 25% penalty, but you don't want to have to pay 25% of a RMD you forgot to take on time. So we want to deal with that. And then post-mortem planning, we want to shift assets to minimize future estate taxes and revise your plan to make sure that the survivor is still protected. Of course, we have to deal with all funeral-related functions. The surviving spouse or the next of kin is technically entitled to possession of the body for burial or other, cremation or whatever is going to happen. The public burial lots pass to the heirs at law under Massachusetts law, and expenses can be paid by the family, but the estate or trust can reimburse some of these expenses. I often talk about when we're doing things, when we're talking about funeral expenses, if you have something extravagant. My dad had a client years ago who said, gee, I'd really like my ashes spread on Mount Olympus so I can be with the Greek gods. And I want you, Keats, to take my ashes, fly over to Athens, and climb up on Mount Olympus and spread the ashes. Well, in order to do that, that's something extravagant would need to add a specific authorization and a specific instruction into your will in order to authorize the payment of that expense from the estate. I sometimes kid, we want you to take our ashes off to where we had our honeymoon, take a cruise, take the whole family, and have a wonderful time on us, make it a happy experience, and as we leave the harbor where we had our honeymoon, dump our ashes off the back of the boat, and we'll be there forever, and we're happy, you're happy, but let the estate pay for that expense. You got to put that in the will. But other than that, if you're doing your typical funeral type of arrangements, you can use your standard memorandum, and we're not going to be too concerned about building that expense into the estate. Automobiles, if you're married, I'm jumping ahead. Registration is effective until it's expired. Your insurance is effective until the renewal. So you're still insured. Having said that, though, best practice, park the car, do not drive it until somebody can retitle that vehicle into whomever is going to inherit it. Because if you get into a car accident, technically the estate is not insured. And you don't want to have a problem with somebody saying, I'm suing the estate, and the estate doesn't have insurance coverage. All right? So best practice is to get the car title changed. If you're jointly owning the car, then it's going to pass automatically. If it's owned only by the decedent and the decedent was married, there's an affidavit procedure where we can quickly and easily change the ownership of the vehicle to a surviving spouse without the need of probate. So let's just get that done. That should be one of the early things. We do need to get an appraisal of the vehicle as soon as possible after death so that we can get what's the car worth if we have to file an estate tax return. We often use services like Edmunds.com or KellyBlueBook.com. Go onto those, put in your make, model, maybe your VIN number, and it'll come up with, well, what would you get if you traded it in? What would you get if it were sold to a dealership? Or what would you get if it's sold on the open market to a third party? It's that last one that's the value of the vehicle that we need to use. You want to get it sooner because as more time goes by, the car devalues, it's less accurate. So that's something that most families will do themselves. After the funeral, what's the most important thing to do next? To stop. I've already said this, but you don't want to start acting until you know the consequences of your action. Don't retitle a joint account. It prevents the ability to disclaim it. Don't notify financial institutions because you risk being locked out of your own bank account or your own investment account. If it's only owned by the deceased spouse and you notify the financial institution, they have to freeze it. You cannot get at that money. So don't do that right away. We want to time it so that if there's automatic payments coming out of that account, we might want to get the next payment, then notify the institution so that you don't lose that income stream and have access to that money. Don't make a claim on a qualified account like an IRA or a 401k because sometimes that might lose tax deferral if it's not done right. You don't want to make a spousal rollover of retirement accounts or life insurance because that can sometimes cause unnecessary estate taxes at the second death. So we just want to stop, go over things. Instead, what we want to do is talk to your attorney. It doesn't have to be the drafting attorney. So if you do your plan with us, your kids don't have to work with us. We hope they do, but your kids are free to go wherever they want. Similarly, if you become a PR for somebody else, you don't have to work with the drafting attorney. If you want, you can call us. But you want to know what to expect. Fees are usually going to be charged on an hourly basis, and it is a start and stop process. Hurry up and wait, as we used to say in the Air Force. You get to a point, you do something quick, and then you're waiting for the wheels of progress to turn ever so slowly. We put an application into Fidelity to retitle the account, and they might take 30 to 60 days to get that work done. So it's hurry up and wait. And you should expect that process to be over a year long. Now, there are times where we can do it more quickly than that, especially if there's no estate tax return required, but it's going to take some time to do this stuff. That first meeting with the attorney is really about gathering information, providing guidance. That newsletter that we gave you all has almost everything that we're going to ask you to try to gather. So it's a good resource. Hold on to that, stick it in your binder, remind the kids, or if your spouse, make sure everybody knows that this is what's required. You've got to provide the documentation, and you can ask questions in that initial meeting. And oh, by the way, the Hollywood reading of a will, I have never done one, and I really don't expect to, okay? It makes great TV, great movies, but it's not reality. So there isn't really that formal reading of the will, all right? So here's some things that we need to know about. Your estate planning documents, where are the originals? Certificates for death, prior year's income tax returns, any gift or estate tax returns if they've previously been filed, deeds for any real estate, retirement account statements, your checking, money market CD statements, brokerage account statements, stock certificates if you still have the paper stock, savings bonds, life insurance, annuity, proof of debts like the funeral bill or hospital bills or anything like that, certificates of title for the car, and anything else that's important. If you have a country club membership that when you sell it back, you're going to get money back, that's an asset. We need to know about it. If you've loaned money to the kids, there should be a promissory note. We need to know about it. We want to make sure they don't say, oh no, that was a gift. I don't have to pay that back. So you want to document that stuff and have the piece of paper. And then look before you leap. We're going to compile an inventory. We're going to figure out what it is. That's that initial meeting where we try to figure out what are we working with. We don't want to assume anything. We don't want to rush. We got to keep an eye on that big picture. We're going to, as I said, review the estate planning documents, determine who is the personal representative, what happens to the personal property. Is it a pour-over will? We got to look at the trust, and if you have an IRA trust, who's the trustee? Who are the beneficiaries? Are there special distributions? We're going to determine, identify, and review. Determine the identity of the successor trustee and personal representative. Remember that after you die, your power of attorney doesn't matter anymore. Once your power of attorney knows that you have passed, they have no power to do anything. We're going to identify the beneficiaries and the distribution scheme, and we're going to review important provisions for problems. So make sure that we don't have anything unexpected come up. We're going to determine who's in charge. The fiduciaries have to accept their role. Just because you name somebody as your successor trustee doesn't mean they're going to take the job. And sometimes they're doing you a favor if they don't take the job. We had one estate many years ago where the nominated successor trustee was a very busy professional. He had his own business to run. He had the skill set, but he didn't have the time. But he felt the moral obligation to take on the job, and it never got done. It took several years for his family to finally convince him, look, you're not going to get this done. Resign, we'll take over, we'll get it done. So you want to make sure you got the right person. They got to accept. Don't choose too many people to be in charge. If you've ever been on a committee, you know how efficient they are. This is a job to get done as quickly as possible. And you don't, if you have got too many people involved, you got too many opportunities for disagreement. We had one case where we had 4 children as co-trustees. To get everybody on to all of the accounts, paperwork would go out to one child. We'd have to wait for them to go out to get the signature guarantees. It would come back to us, sent it out to the next child. Another couple weeks would pass, got it back, sent it out to the third child. Oops, I lost it on the train. Let's start all over again. This went on for, I think it was 7 years. Too many people involved means too many decisions, too long a process. So try to streamline things. Don't give the job to a busy child, and don't rule out a professional. Yes, they're going to charge a fee, but sometimes that's better to get the professional to do that work than to put it onto the kids who may not really understand all the necessary steps. They have to accept their roles on the trust, the IRA trust. If there's a real estate trust and a personal representative, there's going to be a probate. We have to sign the paperwork, an acceptance or a declination. We have to sign some form of an authorization to disclose information. If we're helping the family out, we want them to give us permit. We want the institutions to release information to us. They have to sign something to authorize the institutions to be able to talk to us. They may need a HIPAA authorization. If they become incapacitated, we need a letter from their doctor so that the next person can come on. And if we don't have a HIPAA authorization, we have to go to court. We're talking 30, 40 grand just to get a letter from somebody's doctor without a HIPAA authorization. You don't need to do that. Then they need a certificate of trust. All right, at this point, I've gone on a little longer than I thought I would. I'm going to bring Whitney up to go through our CARES process, something that I think will help you understand what the process is for settling an estate. Whitney, thank you.
So I'm going to talk about the acronym that we've created, and we refer to it as CARES. So CARES is the acronym that we've associated with a 5-step process that really applies to everybody's estate administration. So regardless of the size of your estate, these 5 steps are going to apply. So whenever anybody passes away and they come into the office and they sit down for their consultation, regardless of estate size, we say to them, these are the 5 steps that we are going to have to go through. So this is really, if you want a snapshot to write some notes down, these are the 5 steps that are really going to apply. So the first one is taking an inventory, and I'm going to go through all of these in greater detail, but the first one is taking an inventory. The second one is getting appraisals on all of the assets that the decedent owned when he or she passed away. The third step is retitling all of those assets. The fourth step is evaluating taxes, and that could be a combination of income taxes, estate taxes. There's a number of taxes that we need to be concerned with. And then the 5th step is splitting and distributing the estate, okay? So those are the 5 steps: inventory, appraise, retitle, taxes, and distribution. Now, the first step is the inventory. And so this is the process where we're trying to locate assets, determine ownership of assets, and beneficiary designations. When a client comes into the office for an estate administration consultation, the first thing we do is that we give them a letter. It's got 25 or 26 items on it. It's everything that your beneficiaries should be looking for: bank accounts, brokerage accounts, life insurance policies, real estate, annuities. It's a comprehensive list. Even if 5 of the 25 things apply, they're everything that you're trying to have your children look out for, because oftentimes, while we do have maybe an idea of some of the assets that the client had when they initially came into the office to create their estate plan, things change over time. So maybe they acquired a new CD or a high yield savings account. Maybe they acquired an IRA from a parent. Assets change. So just because we had a good idea of what the assets were when the client came into the office doesn't necessarily mean those are the same assets that exist when the client passes away. So there is a little bit of us relying on the beneficiary when he or she comes in to give us a rundown of these are the assets that existed when mom or dad passed away. All right. How assets are owned will impact all of the other acts of the settlement process and the effectiveness of the estate plan. So again, when we look at how are assets owned, real estate That's us going to the Registry of Deeds and pulling the current deed to see, is it owned by the trust that we created? Is it owned jointly with someone? Is it owned as husband and wife, tenants by the entirety? We go to the registry and we figure out how is that real estate owned. The next one is IRAs and qualified plans. So retirement accounts, those typically pass through a beneficiary designation. And so while you're the owner, we don't necessarily know who the beneficiary on file is unless we can see a signed beneficiary designation from the custodian. So we want to know what's the most up-to-date beneficiary so we can make sure that that retirement account rolls over to that appropriate beneficiary. Banks and brokerage accounts. We want to review the statement for date of death to check title and confirm with the company if it's unclear. So what we're doing here is we're saying to either the surviving spouse or the children, can you get us a recent statement so I can see how that statement is titled? Is it individually owned? Is it joint with someone? Did you get it into the trust? That's usually a quick glance. A quick glance at that statement tells us how is it owned. And then life insurance and non-qualified annuities, again, similar to retirement accounts, life insurance policies usually pass by a beneficiary designation. And again, we want to reach out to the custodian and say, confirm who is the beneficiary for the life insurance policy. This here, just so everyone can just take a quick look, when we have a new estate administration client come into the office, while we're compiling all of the assets and gaining the inventory, what we do is we now put it into this chart. So this chart is divvied up by asset category. So at the top we have real estate, then we've got retirement accounts, regular brokerage accounts, cash accounts, and some oddities, promissory notes and closely held businesses, and then life insurance and miscellaneous property. What we're doing with this is we're working on it over time. So as we're gaining information about the assets, we're plugging those assets into this chart, we're gaining date-of-death values, and we're plugging it in so that we have a good idea of everything that existed. So this is what we use for everybody, again, regardless of estate size. Now, step 2 that I talked about was appraisals, getting appraisals on all of the assets. Now, traditionally, when we think of an appraisal, we all think of an appraisal on real estate, where a paid appraiser comes out to the real estate and they appraise the fair market value of the property. It's important that everyone knows that appraisals in an estate administration case are relevant to real estate, but it's also relevant to all of your other assets. So brokerage accounts, stocks, bonds, mutual funds, we need to know what was the value of the brokerage account? What was the value of the IRA account? What are the values of everything? And there's 2 reasons why we need to get appraisals. The first reason why we need to get an appraisal on all of your assets is because we need to know what was the total size of your gross estate when you passed away. Massachusetts has a $2 million filing threshold, an estate tax filing threshold, which means once we have a good idea of everything and we put everything into this chart, if the bottom line number is $2 million or more, we know that within 9 months of date of death, we need to file an estate tax return. So that's one reason why we're getting the appraisals, so we have a good idea of what everything's valued at. The second reason why we're getting appraisals is because we want to know what is your new cost basis. When you hold an asset until someone passes away, we're able to change the cost basis from what you purchased the asset at to what it's valued at on date of death. So if you purchased your real estate at $500,000 and you've held it until you passed away, and when you passed away, we get a paid appraiser come out to the house and the appraisal comes in at $1 million, we're now able to step up the basis so that way now your new basis is the $1 million. So if the surviving spouse said, I don't want to live here anymore, I'm going to sell, you're helping to avoid any capital gains tax because we got to step up in cost basis. So those are the 2 reasons why we need to get appraisals on everything, okay? Some appraisal issues to be aware of. Oftentimes we have a client come in and say, well, can't I just use the assessed value on the town's website or the Zillow value or a market analysis? The IRS says no. In order for us to accurately convey an appraised value on the estate tax return, we need to get a paid appraisal on the asset, okay? So certified appraisal required. prohibits the use of realtors market analysis. Assessed values are not market value. We can't use assessed values. Investment accounts, again, we can't just look necessarily at the statement. While the statement does help us get a good idea of what the holdings were, there's a very specific way that we need to get the valuation of stocks, bonds, ETFs. We need to use the high and the low on the day and get the average of the high and the low on the day that the decedent passed away. That is different than just looking at the value that the statement says. So there's a way to get that valuation. Typically what we do is we write to the company, they give us a rundown of all the holdings that were in the account, and we plug it into a system, and the system tells us this is exactly what the date of death value was. It's the same program that the Department of Revenue and the IRS uses, and so that way when we are reporting the valuation on the 706, the estate tax return, we know that they're not going to audit us on that. We've appropriately conveyed the valuation. All right, bank accounts, important to know that we want to include accrued interest to date of death, exclude any uncleared checks, and then life insurance and annuities, the policy face value may be wrong. The documentation that you need to provide to the DOR or the IRS is what we call a Form 712. A Form 712 identifies the value of the life insurance policy on date of death. Typically, we cannot get a Form 712 until the claim has been paid to the beneficiary. So we prepare the claim gets paid, the beneficiary gets a check, then we write to the life insurance company and we ask them for a Form 712. All right? Step 3 is retitling assets. Retitling assets depends on how the asset was owned when the decedent passed away. Okay, so for example, change ownership to the fiduciary, PR or trustee, or to a beneficiary of a life insurance policy or an IRA. So starting with the easy ones. If you have an IRA account that has a beneficiary, the retitling of the IRA account or the life insurance policy that had a beneficiary is simply giving the asset to the beneficiary named on file at the institution. If you're looking at an asset that was owned by the trust, though, now the trustee has passed away. So while we're in this 1-year phase of administering the trust, we need to make sure that whoever you named as the successor trustee on the trust is actually put on record onto that asset at the institution where the account is. So for example, if you had a brokerage account and you were the trustee and that account was operating under your social security number and now you've passed away and your daughter is the successor trustee, well, 2 things have happened. If you were the second to pass away, your trust has become irrevocable, which means it gets a tax ID. The second thing that has happened is the trustees have changed. Your daughter's come on as trustee. So we need to make sure that we are updating the title on record at the institution where that brokerage account is, so that way we can make sure it's operating correctly under the new tax ID with your daughter as the trustee. If you've got an asset that is a probate asset, okay? So you passed away with an asset that was individually owned by you. An individually owned asset is going to have to go through probate, which means that's something that now needs to be retitled, not in the name of your trust, but in the name of your estate, with whomever you have named as personal representative of your estate. So every asset has a way of being retitled, okay? And it's necessary to take all future actions, and the reason why it's necessary is because there's a hold on an asset. So for example, if there is an asset that was individually owned, you can't do anything on that asset unless you have custody over that asset. So either the trustee needs to come on a trust-owned asset, the PR needs to come on an estate-owned asset, but you need to gain custody, and each asset has a way of you gaining custody over it. All right, and so whether you're a PR of an estate or a trustee, we want you to make sure that that person is reviewing the investment portfolio, maintaining insurance if there's real estate. So if we're holding real estate until the real estate sells, that real estate needs to be insured. So we need to make sure there's homeowners insurance on that as well. All right, and then access to funds required. You know, it might be that we need to provide for the surviving spouse and the family, pay administration costs and expenses, pay pending estate and income taxes. You know, Keith said earlier, typically there's a couple of ways that we do that, but it really should come from the trust if we're able to take it from the trust at that time. All right, Ability to control assets depends on the type of ownership. I did just briefly touch upon this, but again, individually owned, that means that we need the personal representative to come on to take custody of that probate asset. Individually owned with a beneficiary designation. Think IRAs, life insurance policies. That's paying the account down to the beneficiary on file. Co-ownership, okay? If we think of co-ownership, joint tenants. So many times we have a client come in, a married couple. They have a bank account that's a joint asset. By operation of law, any joint asset where two people are the owners of an account, it'll automatically revert to the survivor by operation of law. The issue with joint ownership is because once the survivor has now gained custody of the account, now that account is an individually owned asset, and there's something we would need to do to make sure we get it into your trust or take care of it in another way. Tenants by the entirety, that's referring to joint ownership for married couples. You'll see that oftentimes married couples, when they purchase real estate, they purchase it as husband and wife tenants by the entirety. It's the equivalent of joint ownership for a married couple. And then pass by probate, tenants in common. Tenants in common is, honestly, it's individual ownership. So tenants in common, while you might think of it as joint ownership because maybe 2 or 3 people own an asset, if you've got a piece of real estate and that real estate is owned 50-50 tenants in common, that's really, that 50% ownership is an individually owned asset that is a probatable asset, okay? So don't confuse tenants in common with joint ownership. Joint ownership reverts automatically to the joint survivor. Tenants in common needs to be probated. It's an individual ownership. Okay, and then in trust, this is really the best method because it accomplishes probate avoidance at the first death. It accomplishes probate avoidance at the second death. It has your testamentary disposition, who's going to get what of your assets when you pass away. Incapacity care planning, so the trust says not only at death, but if there's an incapacity, we're providing for who's going to step up to be your successor trustee on the document. So even if you're alive but you're incapacitated, the trust provides for who's going to come on to now help you if there is an incapacity. And then estate and income tax planning and asset protection. All right, joint property and beneficiary designation. Simple to take possession because, again, just as I mentioned with joint property, it automatically passes to the surviving owner. So if there was a joint bank account, it's nothing more than providing a death certificate to the banking institution and that account is now yours. Same with a brokerage account or any other asset. It automatically goes to the survivor. We want you to be aware of unintended consequences of joint property though. So unintentional disinheritance, that's important. If you're the surviving spouse or you're a single person and you put your child on an account as a joint owner with you, so whether that be real estate, a brokerage account, a bank account, joint property, whether it's joint with a spouse or joint with a child, automatically is going to go to that joint owner. So if you put your child on your real estate and now you pass away, that piece of real estate's going to go to your daughter if that's who you put on the deed, because by operation of law that's where it goes, and that might not be where you really wanted it to go. You might have done it for convenience. So be very careful about making assets joint with anyone other than a spouse, okay? And so one reason is disinheritance. The other reasons are, first of all, there's gift tax issues. So when you put someone onto a piece of real estate or a large asset, if you're putting that person onto an asset that's greater than the $18,000 federal gift exemption, you're basically making a gift to them. It's probably an unintended gift, but it's a gift nonetheless because you've given them an asset greater than that exemption amount. Also creditor exposure, I skipped over that one. If you put your child on an asset and your child has a problem in life, someone sues your child for something, your child is going through a divorce, now that problem can become your problem. So even if your child didn't contribute anything to that asset, it's your money, but you put your child on, well now it looks like your child is an owner, and that's all that matters, okay? And so it's a problem. If your child has a problem, their problem is now your problem. So be very careful about making assets joint with anyone other than a spouse. okay? Beneficiary designations, IRAs, life insurance, annuities, brokerage accounts, again, fairly straightforward. It passes to the named beneficiary by contract, okay? It is important to note that oftentimes I feel like I have clients come in and they say, well, I've got an IRA and it's got a beneficiary, and then these are my beneficiaries in the trust. The beneficiaries in the trust are only relevant to what the trust owns. So what your IRA says on file with an institution, or what your brokerage account says as a beneficiary on file with an institution, that is separate. It is going to pass by contract to whomever is named. It is separate than what is contained within your trust, okay? You had a question?
Yes, let's just say I have 3 kids, and let's just say I have $3 million. I wanted to do a joint with myself and each one of the kids, and gave each $1 million. That doesn't go to the estate, it's just a gift.
That's well, one, yes, it is a gift if you put them onto an account like that. The problem with that scenario is that if they have a problem, your asset is now fair game to become subject to their problem. So you don't want to do that, because your asset could be taken away from you if your child has an issue.
And it is still in your estate for estate tax.
Yes, and it still counts. Oh, that was your question. Yes, it still counts. So for estate tax purposes, whether your asset is owned with a spouse or it's owned with your children, it counts. It counts no matter what. The only difference is that when it is owned with a spouse, you only have to report 50% of the asset on the estate tax return. If it is owned by anyone other than a spouse, then you have to include the full value of the account on the estate tax return. All right, individual versus trust-owned assets, okay? So individually owned, meaning no POD, TOD, or beneficiary designation. Those stand for pay on death, transfer on death, and then beneficiary designation. An individually owned account that has one of those PODs or TODs associated with it will avoid probate. But if you've got an asset that's individually owned and for whatever reason you didn't get it into the trust and you didn't put a beneficiary on it, it is an individually owned asset that will require probate, court involvement, and appointing a personal representative. Now, we want to stress here that probate is only going to happen to you if you have not properly funded your trust. The goal is that everything is in your trust, and if it's not in your trust, it's got a beneficiary designation. And so the hope is that we don't have any probatable assets. So I don't want to emphasize probate, but I just want to explain what happens when you have an asset that didn't get into your trust or didn't have a beneficiary designation. That is a probatable asset. Yep.
What about vehicles? We have multiple vehicles.
Yeah.
You know,
Yeah.
Don't put them in the trust.
Right. No, you can't put them in the trust.
Probatable, or-
So if you are married, okay, Massachusetts has an affidavit process, which means if you're a surviving spouse, you can take advantage of the affidavit of surviving spouse. There's one other form that goes along with that. You need an original death certificate. You can make an appointment at the registry, and you can avoid going through probate to transfer the vehicle to the surviving spouse. The issue in that scenario is, so now say you're the surviving spouse and you have a child. Okay, you didn't get rid of the car before your passing. Now the child will have to open a small probate to gain custody of the car to be able to either transfer it to themselves, sell it, dispose of it, do whatever it is they're going to do with it. The affidavit process only applies if there's a surviving spouse. If you're a second to die, there's a probate. All right.
At any cost? At any amount?
There's 3 types of probates in Massachusetts. The one you kind of hope for if you have to go through probate, we refer to as a voluntary administration. $25,000 or less, plus the value of 1 car. Over that amount, we have to file what we call an informal probate, which is more along the lines of a traditional probate. It's your 1-year time period. So you want to avoid that. But if you've got $25,000 plus the value of a car, no matter whether that car is a low-value car or you've got a $100,000 car, you can qualify for the voluntary administration. Okay? Trust-owned assets, no probate at the first death, no probate at the second death, no court involvement. The controlling document is the trust, and the fiduciary in that case is the trustee. Okay, so the goal is that we're very careful about making sure you fund your trust. If you fund your trust, those assets are not going to have any court involvement. You're not going to have to go through probate for those assets. All right. Now, just to highlight what is probate, oftentimes we get the question, what really is probate? Probate is a legal process to prove the decedent's will and appoint a personal representative to carry out its terms. It's the only method to gain control over assets held in the decedent's name alone, okay? And now the second point is really important too. A couple years ago, I had a client who had Massachusetts property, but his wife had passed away, and his wife had a Walt Disney timeshare, okay? That Walt Disney timeshare, what had to happen is we had to refer him out to a Florida attorney, and he had to open up an ancillary probate in Florida, because depending on where the asset is located, if you've got an individually owned asset in Florida, I can't open a probate in Massachusetts to take care of a Florida asset. We need a Florida attorney to open a Florida probate to handle that asset. So be careful about having assets in other states if they're not owned by your trust or there's no joint owner on them, okay? This is when I was just talking about a couple minutes ago. 3 types of probates in Massachusetts, varies in complexity. When I say it varies in complexity, it really has to do with the value of the account. If your assets are $25,000 or less plus the value of 1 car, you're in a very simple probate known as a voluntary. Over $25,000, we refer to it as an informal probate. Okay, and then beyond that, there are formal probates, and typically there is a specific reason why one would need to file a formal probate. The negative aspects of probate is that there's court fees, higher attorney's fees, loss of privacy because it's a public proceeding. Your assets are out there for people to know about. And slow access to the funds. You know, a probate takes time to open. And so we want you to really make sure we're funding the trust so we can avoid this process, okay? This just is a list of the different types of documents that get filed when you're filing an informal probate. If all we're filing is a voluntary, there's just one document that's known as a voluntary administration, and that gets filed. Beyond that, if we're looking into an informal or a formal probate, all of these documents need to be prepared and provided to the probate court and the appropriate county. After the initial filing, and again, this is not with a voluntary administration, this is only applicable if we're in an informal probate, interested parties must receive notice. We need to publish in the newspaper. We need to prove that we gave notice to the interested parties to the court. There's a return day that is associated with the probate, and that's the date that the parties can object to the will or the personal representative. We rarely see this happen. We rarely see an objection. But just so everyone is aware, there is a return date, and that is the date that someone can object to something. Usually about 8 weeks after initial filing. With any probate, you have to wait 30 days until someone has passed away, although Julia just told me that we only have to do that with an informal or a voluntary? A voluntary. Other than that, we have to wait 30 days. So, and the nominee in the will has no ability to control assets until this process is complete. So we don't want to have to rely on this if we don't have to. All right. I'm going to skip over this. Probate versus trust. Personal representative can only take control of assets when the court allows, and that's upon receiving what we call letters testamentary, or what we refer to in Massachusetts as a letter of authority, okay? Until your personal representative has the letter of authority in hand, he or she cannot do anything on behalf of a probate asset. And there's a delay with probate, and that can cause problems. Maybe you've got a beneficiary who needs a little bit of help, early distribution. If you can't access the funds, you can't provide that distribution to the beneficiary, okay? Trust, on the alternative, gives immediate access and control of the assets to the trustee. As soon as your successor trustee comes into the office and signs an acceptance of successor trustee, that person can start to run with the trust. They can retitle the asset, they can make an early distribution to beneficiaries, and they can pay expenses, any debts of the decedent out of the trust-owned asset. So trust does provide immediate access and control. Just to remind everyone, same retitling of assets, okay? No matter how assets are owned, there's always a retitling process. All right, step 4. Step 4 is taxes, okay? Now, taxes are, there's a couple of different types of taxes that we want to worry about. Income taxes and estate taxes tend to be the big ones. So, if someone passes away, the surviving spouse or the children need to make sure that they're filing the final income tax return on behalf of mom or dad, okay? That's due 15th of April, okay? Decedent's final personal return. Also, we want to know that, are there going to be estate taxes due? Estate taxes are due 9 months after date of death. It is not associated with the same date as your personal income tax returns, okay? So your estate tax return is exactly 9 months from date of death, whenever that is, and you must file by that date. And if there is a tax due, you must pay the tax by that date. Otherwise, we start to accrue penalties and fines for late filing, for late payment. So if there's an estate tax due, it's critical that we pay it on time. While there are options to extend, it is important that everyone knows there is an automatic extension that everyone can get. But if there is a tax due, you do not get an extension to pay the tax. The tax must be due at the 9-month mark. You file the extension with the payment due. And then once you've compiled all of your date of death values and you got everything in good order to submit the return, then you can do that at a later date. But the 9-month is a pretty hard date. All right, so estate taxes, income taxes, 15th day of the 4th month after the close of the tax year, decedent's final personal return, decedent's final gift tax return. If the decedent made a gift in the final year that they were alive over the exemption amount of $18,000 and never filed the 709, then the fiduciary needs to make sure that they're filing that Form 709 on behalf of the decedent to accurately report the gift, okay? Fiduciary income tax returns, probate estate, and the trust. So that's what we call a Form 1041. It's a trust and estate's income tax return. We all file our regular income tax returns, our 1040s. Once an asset is retitled, whether it's a probate asset retitled in the name of the estate or a trust-owned asset titled in the name of the trust, either way, those accounts, they have a tax ID associated with them. The estate gets a tax ID if there's a probate. The trust, once it becomes irrevocable, gets a tax ID. During the administration phase, that account is accruing income, depending on what type of asset you have. But if you've got a brokerage account and it's earning interest and dividends, you know, that income, at the end of the year, the fiduciary is going to get a Form 1099, which means that they need to file a Form 1041, which is a trust and estate's income tax return, to report any income. Okay, it might be that that just has to happen 1 year, depending on how long the administration takes. It might be 2 years. It's hard to say, it depends on the facts. But it's important to know that everybody has to file those returns. Generation skipping transfer tax. If a grandchild, and I'm gonna defer to Keats, but if a grandchild receives a gift or an inheritance, there is a tax that we need to make sure we're reporting accurately. I'm going to defer to Keats on this. The exemption is being accurately reported on the estate tax return to make sure we allocate GST tax. But it's only relevant if you're making a gift to a skipped generation, okay? And then state and local taxes. All right. Estate taxes. This really has to do with that top item that I just talked about, estate taxes that are due 9 months after date of death. This is the Form M706 in Massachusetts. It's the Form 706 federally. Oftentimes people always ask, what assets are included in the estate tax return? And the reality is that everything that you own is included on the estate tax return. So this is a long list of everything that if you owned, we would report, okay? So real estate, IRAs, stocks, bonds, mutual funds, checking, savings, CDs, money markets, life insurance proceeds, non-qualified annuities, cars, revocable trust assets, decedent spouse trust, powers of appointment. The deductions that we can typically take are funeral expenses, final debts, administrative expenses, charitable bequests, assets to and for the spouse, and the exemption amount. But more or less, everything you own needs to be reported on the 706. Okay? These are the exemption amounts. Currently, right now in 2024, the Massachusetts estate tax exemption amount is $2 million, which means if your gross estate exceeds $2 million, we're required to file the Form M706 within 9 months of date of death. Federally, the exemption is 13.61. In 2026, the federal exemption is going to come down to around $5 million indexed for inflation. But these are what the amounts are today, $2 million and $13.6 million. Go ahead.
For Massachusetts, it's $2 million exemption. If someone was under the two, say 1.8,
Yep.
but they had given over the last couple of years gifts,
That's okay. If they gave gifts,
doesn't Massachusetts go back and bring those back in just to see whether you have to file a return?
no. So if you gave gifts, you should have, if you gave gifts in excess of the exemption amount, which currently 2024 is $18,000, you should be filing a Form 709 to report the gifts. The gifts that you're reporting, they're chipping away at what you can give. So they're chipping away at your federal exemption. So if you've got $13 million and you gave away $1 million in a gift, you reported that on your 709, you now have $12 million. Okay, so you're chipping away at your federal exemption. But those gifts, that's separate. If that got you under the 2 million filing threshold and now you're 1.8, you don't have to file for Massachusetts. But I see Keith standing up, which means he must have something to say.
If you're over 2.
All right, filing requirements. So again, Massachusetts has a filing requirement when we're $2 million or more. Federally, the filing requirement is 13.61. Valuation determined during step 1 of settlement indicates the filing requirement. That's why we're getting all of the appraisals, so that we know what is the gross value. You know, Julie and I recently had an estate administration. We got all of the valuations. It was like 1.9, and so, you know, just by $100,000, they didn't have to. The family didn't have to file an estate tax return. And of course, we triple checked to make sure everything was correct, but we were right under that exemption. Filing is still required if no tax is due. So what we mean by that is if the gross estate is $2 million or more, and especially at the first death. If at the first death, you know, when we have a married couple, if the estate is over $2 million, we still have to file even though there's no tax due. We take something called a marital deduction, which effectively pours all the assets over to the spouse. But so there's still filing sometimes even if there is no tax due, and it's typically at the first death. Optional filing, when to file even if not required. Oh, go ahead.
So on first death, you'd still have to file a massive estate tax return.
If the gross estate's over $2 million, you still file the return, but typically there's no tax due at the first death because we give everything to the spouse. And so what you're doing is you're delaying the tax until the second death.
So there's a filing requirement.
There's a filing requirement.
For federal, first spouse dies.
Yep.
And you want to carry over
The federal exemption.
federal exemption.
Then we would want to file, and that's in this bottom point here, that's the portability election. The only way we can port over the unused exemption of the first spouse to die is by filing a federal 706. It only exists on the federal level. Portability doesn't exist in, you know, on state for Massachusetts. But the way we get that unused exemption and we port it over to the spouse is by filing federally. So that way,
So you file a federal estate.
even if we were below 13.6, just for portability purposes.
So you got to list all the assets.
Yes.
All you got to do.
You got to do the whole thing. You have to submit all the supporting documentation. You do it just
The box that says
Right.
I want to port it over.
right. I'm pretty sure it's actually, you don't actually have to check off a box. You can opt out of portability, which we never do, almost, right? Yeah, I mean, almost. All right, so statute of limitations, basis adjustment, portability election. I just talked about portability election. Basis adjustment, we want to make sure that we are appropriately stepping up the cost basis so that way if the IRS were to audit, they've got 3 years to check the basis that you reported on an asset to make sure that you've accurately stepped up the basis to the appropriate value. All right, this is going back to portability, new concept, transfer unused exemption amount to the surviving spouse. Married couples can pass twice the exemption free of federal estate taxes, and it helps insulate against future estate changes. So as I said, in 2026, the federal exemption is going to come down to $5 million. That's why you'd want to file a federal estate tax return, is to make sure you're porting over. So if you, by the time you pass away, if you had $5 million plus whatever the unused exemption of the first spouse to pass was, now you're insuring, or you're not insuring, but you're helping yourself make sure you probably don't have a federal estate tax to worry about. All right, so here, spouse 1 dies in 2024 with an estate valued at $2 million. The personal representative elects to port the unused exemption amount to the surviving spouse's exemption to use during life or at death. Surviving spouse now has 25 to 2. So what that means is, so her own $13.6 million exemption plus the 1161 exemption to use during life or at death. So it's a way of passing more exemption at the second death. And we're doing this to minimize future estate taxes. Yeah.
You always talk about the first death and the second death. What if the big bus hits you both at the same time? It's a little morbid, but assuming so, would the co-trustee on your trust actually be the person that becomes the next automatically?
So is your question related to the estate tax, or just what happens? If both of you are, something happens to you simultaneously, then your trust is going to have a successor trustee. That person is going to accept their position as successor trustee to be able to administer the estate and take care of everything they have to take care of.
Okay,
Right.
thanks.
Massachusetts, $2 million, right? So if your estate was $2,100,000, do you only pay on the difference? That goes back.
The formula technically starts at $0. That's how the formula works. However, if you have a $2.1 million estate, typically the tax almost always comes out to about 10%. Keith says, no, not anymore?
Not anymore.
Okay.
With our new estate tax exemption, the cliff went away. So
Oh.
we don't go back to $1 and tax everything. We only tax the amount over the $2 million on that last $100,000.
At about 10% still.
Yeah.
So like a $10,000 tax, yeah.
That's great.
All right. So one other thing to note for portability is that the election is not automatic. We have to file a timely return. Again, federally, 9 months from date of death. Portability doesn't just automatically happen. You have to submit the federal return. All right, these are due dates, 9 months after date of death. Automatic 6-month extension. Massachusetts, not automatic, but rarely refused. We do have to file an extension in order to get the extension. I've never had the extension denied. That, again, though, doesn't pertain to payment. Payment is required at 9 months. Otherwise, if a payment was due, you are accruing interest and penalties. And then who files? So duly appointed personal representative. So if there was an estate opened, a probate estate opened, then that means you've got a duly appointed personal representative. The personal representative is typically the person who should file and sign the estate tax return. If you never had a probate opened, which is what we all hope for, then you don't have a probate opened, which means you don't have a personal representative, but you do have a trustee on your trust, or you have somebody in possession of the assets. So the person who is signing the estate tax return is either your personal representative or it's the party who's in possession of the assets, which is typically the trustee. All right, closing letters. Your liability is not fully discharged until a closing letter is received. Now, when you submit a return to the Department of Revenue, as a matter of procedure, always sends us a closing letter. along with a lien release, which is at the bottom there. So something that people don't often realize is that whenever anybody passes away, an automatic lien is placed on property. Okay, and one of the ways we release that lien is if your estate exceeded the filing threshold of $2 million, then the only way you get the lien release is by filing the estate tax return. You wait for the Department of Revenue, they send you a closing letter and a lien release. We record the lien release at the Registry of Deeds with a death certificate, and that effectively clears the lien. Federally, the IRS doesn't automatically send you a closing letter. In order to obtain a closing letter from the IRS, you actually have to write to the IRS and request a closing letter, okay? Final step in the settlement process is splitting and distributing the estate. We must follow exactly the terms of the will and the trust. Assets pass to beneficiaries and heirs, either outright or through a personal asset trust if we've got personal asset trust provisions in your trust. Just quickly on what the differences are. Outright distribution means we're giving the assets directly to your children. If that's how you designed your trust, we must honor the terms of the trust and give the asset directly to your child. Many of our clients have opted to incorporate personal asset trust provisions in their trust. What that means is that your trust is basically divvying out into sub-trusts for the benefit of your children. The reason why clients have chosen to go this route as opposed to an outright distribution is because it's got asset protection features built into it. If your child has an issue like a divorce, a lawsuit, a bankruptcy, is on government benefits, a personal asset trust type of distribution protects the assets so that your child doesn't lose the asset to some issue that he or she may have, okay? Whatever the trust says, whether it's an outright distribution or a personal asset trust, we need to make sure we follow the terms of the trust precisely and get the assets out to the kids. All right. Probate, two scenarios. Probate, generally all probate assets pour into the trust. So what that means is when you have a trust-based estate plan and you've got a will, the will typically is going to pour all of the probate assets into the trust, combine it with the trust when we're ready for distributions, and then the distributions come from the trust. All right? If there is a trust, we want to make sure that we're considering the possibility of using a disclaimer, okay? And that would be used to reduce your estate size for estate tax purposes. All right? So consider disclaimer to minimize estate taxes and provide for the spouse. That means that your trust, we might be funding the remainder share, the special marital share, and the general marital share. Part of that depends upon how large is your estate, and so that's gonna dictate whether we actually fund these shares. Surviving spouse, if we do fund these shares, gets the income, gets income and principal for reasons of the HEM standard, health, education, maintenance, and support, which means if we are funding the remainder share, the special marital share, or the general marital share, the surviving spouse can use the income for any reason and can tap into the principal for the HEM standard, the health, education, maintenance, and support. All right, when a spouse has passed away, now if it's a second spouse to pass away, now we distribute the assets to the children or the other heirs named in the trust. This here is showing us an example of a trust that has $15 million in it, all right? So if we have $15 million, we're likely going to make a recommendation to the surviving spouse that they should probably make a disclaimer to try to help reduce their estate size. Massachusetts has a $2 million exemption, which means that the family trust, which we often refer to as the credit shelter share or the remainder share, we can fund it with only $2 million. We can fund it with more, but you're only going to get the benefit of funding it with $2 million. Anything over $2 million then goes into the special marital trust, okay, which would still count for Massachusetts estate tax purposes, and anything beyond this amount would go into the general marital, okay? So over that $13 million, the rest is gonna go into the general marital share. The first $2 million goes into the family, then we've got the 11.6 in the special, and if you had anything beyond that, then you'd fund the general marital, then you'd fund the general marital trust. It is important to note that, though, that we want a surviving spouse to come into the office so we can do an analysis with them. When we're funding the family trust, it's important to note that the surviving spouse, when he or she passes away, the kids are not going to get a second step up in basis. So while it is an excellent estate tax reduction technique, anything you don't put into one of these shares is going to get a second step up in basis. So sometimes we need to do an analysis to say what's going to be the better tax to avoid, the estate tax, which is why we would fund some of these shares, or the capital gains tax. Okay, when you're putting something into one of these shares, you're not getting a second step up in basis, and so if they are highly appreciating assets, there could end up being a capital gains tax that turns out to be worse than the estate tax. All right, trust division, physical division of assets occurs. Improper funding formula can lead to unnecessary estate taxes. Improper funding valuations can cause unnecessary capital gains tax. That's what I was just talking about a moment ago. We want to keep future projected growth and the future basis adjustment in mind. You know, when I talk about that analysis, we take a couple of things into factor. Does the surviving spouse have highly appreciating assets or not? What's the age of the surviving spouse? You know, if the surviving spouse is, you know, well into their 90s, the reality is that there might not be too many years left, so we don't care as much if they're highly appreciating assets, because the longevity is maybe just a few more years that the surviving spouse has. But if we have a surviving spouse who is quite young, we want to be careful about funding these shares with highly appreciating assets, because it could turn out that the capital gains tax is worse than the estate tax. So it's an analysis that we want to do with the surviving spouse. Here we've got a trust which is divvying out into PAT shares, okay? So here we have Marcia has a PAT. She's got 1/3 of the trust-owned assets. She's considered to be the perfect child, and she controls her personal asset trust. When the assets divvy out into these personal asset trusts, unless there is an issue, typically your child can serve as the trustee of his or her PAT share. So they control the use and investment. They can invest how they like. They don't need to invest the same way that Jan invests her PAT share, okay? But if there are, say, for example, addiction issues, we have somebody who's got a problem with drugs, alcohol, gambling, some issue, well, then you might not want to put your child on as trustee of their PAT share. You might want to put somebody else on as trustee of their PAT share to make discretionary distributions out to that beneficiary. All right? And then here, we have Cindy's PAT, who's too young, so we've done a step distribution at ages 25, 30, and 35. Our trust reads that unless you request otherwise, the age of distribution is 25. But if you've got somebody who's a very young beneficiary, you might want to leave them their assets in a stepped manner. Rather than giving them their full 1/3 upon the passing of the second of you to die, we want to give them assets in steps so they don't blow through things. All right, so we want to consider no issues, potentially issues where you might want discretionary distributions. You might want to consider step distributions as well. All right, notes, in-kind distributions. Okay, so trust distributions can be done in two ways. One is you liquidate the assets and you distribute cash. The other alternative, which is usually what we would recommend, is in-kind distributions, okay? So for example, you've got a brokerage account, it's got 100 shares of Coca-Cola and you've got 2 beneficiaries. Rather than liquidating your Coca-Cola stock and distributing cash proceeds, you say, I'm going to give 50 shares to the first beneficiary and 50 shares to the second beneficiary. Allow each beneficiary to decide what he or she wants to do with the asset. So if the beneficiary said, okay, well, I really don't like Coca-Cola, I'm a Pepsi person, now that person can liquidate. But usually what we want to try to do is give to the children what mom or dad owned when he or she passed away, then let the beneficiaries decide for themselves what they want to do with the asset. personal asset trust provisions are not automatic. You have to build them into your trust. So all of our clients here today, if you're looking for asset protection for the kids and the personal asset trust provisions are not already incorporated and drafted into your trust, it's not going to happen. Your child cannot create it for themselves. We will have already needed to draft it into your trust, so that's what happens upon your passing. Okay? Go ahead.
How do you split property doing that?
You can. They can.
You don't want to sell it.
Yeah, if you don't want to sell it, and you've got, are we talking about outright distributions or personal asset trust? It doesn't really matter. Outright distribution, if you've got two beneficiaries and they want to hold the property, typically then they would own it as tenants in common.
'Cause I have one of those.
You have a personal asset trust, yeah. Okay, so we distribute to each child's personal asset trust as tenants in common. So you've got the Whitney Taston Trust for the benefit of Jane and the Whitney Taston Trust for the benefit of John, and together, so those are the names of the personal asset trust. So assume I had two children, Jane and John, okay, and those were the two beneficiaries of the trust. We establish the personal asset trust. Now what we do is we create a new deed, a deed from the Whitney Taston Trust to the Whitney Taston Trust for the benefit of Jane, for the benefit of John, and then they own the property as tenants in common. Jointly. Well, yes, jointly, tenants in common. Yes.
If you have an irrevocable trust, because your wife died, can you add a personal asset trust?
Did you create an irrevocable trust from the outset, or are you saying a portion
My
of
wife died,
and the trust became irrevocable? So in his scenario, wife dies, trust became irrevocable. Can you add the personal asset trust then? I don't know if he's referring to a share, like we made a remainder share, or if the trust is just irrevocable.
It's unlikely it would, it's not likely it would be easy, but it's likely possible. We'd probably have to get everybody to agree, then you've got questions as to whether or not the beneficiaries are trying to asset protect themselves. You know, it's really do. I can't say it's possible, but it maybe.
last time I was told it was impossible.
You were told impossible? Well, so this is better news. It's maybe possible. Yes, but it should be, yeah.
All right, thank you.
Usually you incorporate the provisions from the outset or while they're alive. All right. Benefits, like I mentioned, the benefits of the personal asset trust are it's really providing the kids with asset protection from a divorcing spouse, creditor or bankruptcy issues, protecting from government benefits. If you have a child who's on Mass Health, SSI, or some other government benefit, there are certain limitations to what your child can own before the government says, well, now you're in receipt of an inheritance and we're going to take your government benefits away. So if you've got a child who's on government benefits, you might want to consider the personal asset trust. And then avoiding a second estate tax. It's possible that depending on what the size of your gross estate is, you may have an estate tax. When you provide for a traditional outright distribution to a beneficiary, what you're doing is you're adding to their gross estate, because now they own the asset. So maybe you had a beneficiary who had $1.5 million in his or her own right, but inherited from you $600. Now what you've done is you've pushed that child to have $2.1 million of assets, and so you took an estate that was below the threshold, but because you gave them an outright distribution, now they're above the threshold. When you create a personal asset trust, that asset is owned by your trust. Legally on paper, your child doesn't own it. Your trust continues to own it for the benefit of your child, which means it is not countable for estate tax purposes for your child. So it's potentially avoiding a second estate tax on that same exact asset that was already taxed once when you passed away. All right, allowing the child to control the asset, that's typically that's typically the course of action unless the child has a specific problem. And parent maintains control if necessary. All right, I'm going to turn it back to Keats now.
Thank you.
Oh, sorry, it's embarrassing. Oh, yeah.
Well All right, we're going to wrap up in just a second. We've only got a few more slides left to go through. And I appreciate everybody's patience. I know there's been a lot of content here. We're kind of making you drink from a fire hose. I hope, though, it's been helpful. A couple of things I just want to point out. If you haven't filled out an authorization to allow us to talk to your kids, you may want to do that. We have these forms. You may have been given one. If you don't have one, we have them at the back. Talk to the team back there to collect one. We also have given you a little bit of a trustees checklist, some of the do's and don'ts. It's just a little handy reference to get. We also have our maintenance program. I'm going to go over that in just a second. But this acronym CARES, compiling your inventory, appraising your assets, retitling assets, evaluating taxes, splitting and distributing the estate. That's kind of what we've just guided you through over the last almost 2 hours. So I hope that was helpful to get an understanding of what happens. One of the things that we have is something called a Successor Trustees Manual. If you're interested, you can purchase those from us. It's a $50 for a digital or $2.99 if you want the paper with the binder there. But as a little bit of a fun thing, we thought we'd give a random drawing to see, give one of you a digital copy of this today. So what we've done is I've got a random numbers generator on my computer. We've numbered each of you as you registered today. And so I'm going to hit this button and see whose number comes up, and we'll get you one of those. The number is 43, Wendy. Who's number 43? Mr. Holtgren, if you see us before you leave, we'll make sure that you get a digital copy of the Successor Trustees Manual. So I hope you enjoy it. It's a good tool that kind of gives the do's and the don'ts. It gives what happens if there's an it talks about different situations for married and single persons. What happens if there's an incapacity? What happens if there's a death? So it's broken into these 4 sections, and I think it might be helpful for many families. Today, I'd like you to consider signing up for the maintenance program. You get a 10% discount. You get a digital document vault. You might want to order that Successor Trustees Manual. And we're going to send to everybody a hotel vacation voucher just for attending today. I love giving these things away. I hope you will consider taking advantage of it. Essentially what happens is we've teamed up with a travel agent, and they allow us to give to you a stay at a hotel in a number of different places. There's certain locations. There are some taxes and fees that you might be subject to pay in order to take advantage of this, but the hotel stay is our gift to you as a thank you for continuing to work with Boyd & Boyd. There are locations all over the country and international locations as well. So I would suggest avoiding Moscow right now. Israel might not be the best place to go, although I'd love to get there myself someday. But there's some really cool places to go and see, and I hope you'll consider taking advantage of that. Once you sign up for it, you tell us where you want your voucher. We will send to you a link. You click on the link, pay the tax, and then you've got 18 months to book and complete your trip. So please take advantage of that. I had somebody go to Hawaii recently. Someone else went to Paris. A bunch of cool places, Orlando, Las Vegas, Nashville, some pretty cool places, so take advantage of it. And it's okay with me if you share it with your kids instead of using it yourself if you want to do that. Make sure your plan is up to date. If you haven't done an update since 2020, there are a lot of things, most importantly relating to retirement accounts. The change of the estate tax law didn't have a big impact on a need to update, but there's a lot of things you want to consider. If you don't have a contract to plan, you might want to consider that. You may want to upgrade from a simple plan to a basic, or add the PAT and the IRA trust. Make sure you've got the OBIT language, which gets a step up in cost basis for your children or grandchildren when the generation above them passes away. Merge your separate trust into one joint trust in order to get a 100% step up in basis. Make sure you've got a Secure Act. And if your estate is over $2 million, consider adding an irrevocable trust as a tool to try to avoid estate taxes. Now, we want to balance that estate tax savings against capital gains tax cost. Now, sometimes it's avoiding estate tax isn't the right one, but we can sit with you and try to decide what's the best tool. Sometimes we like to add irrevocable trust as an asset protection device for you, so that if you get into a car accident, nobody can reach into your trust and take things away from you. And so using domestic asset protection trusts or spousal access trusts can be a great tool to avoid estate tax, and they can be built sometimes so that we're still going to be eligible for a step up in cost basis. So we have a lot of flexibility and some possibilities there. And as we've said a couple of times, make sure that if there is a death or an incapacity, you do reach out to us. As I mentioned, we've got our maintenance program. If you don't have one of these or you're not on it, you can pick up one of these documents, one of the forms to sign up as you leave today. It gives you, the maintenance program gives you 30 minutes a year at no additional cost. It gives you a document vault so that you can get up into your estate planning documents easily on the cloud no matter where you are. You can get a 10% discount on any of the services. We offer a 10% discount for your kids. The cost is $166 for the balance of this year, and then it's $497 a year after that. And we've already talked about the hotel voucher and the FERPA package. If you've got a grandchild or somebody who's going to college, once they hit 18, the school cannot talk to their parents about their grades, about their bills, about anything going on academically at the school. HIPAA also prevents medical institutions from reaching out to the parents to say, hey, your child's been injured, there's a problem. So we want to make sure that these college students give the right authorizations through the proper forms. Having a FERPA authorization, a HIPAA authorization, a healthcare proxy. Sometimes they should do a power of attorney and maybe even a will just in case, so that we've got the right things in place. So we give a FERPA package with the maintenance program. We've introduced this year a wealth protection and preservation program. It basically adds that we're going to pull your file each year and give it a review internally. We're going to reach out to you for a 30-minute phone call, Zoom meeting to go over what are the pros and cons. Have you got a need? We'll talk about where your kids are. Are they still the right people? And just give a more formal review of your plan. If you need it, you get a short amendment for your trust. We're going to change our trustee from this child to that child. You can update your will, your power of attorney, your healthcare proxy. All of that is included. It's an additional $98 a month, or if you want to do it in one lump sum, it's $980 a year. We also add some other things like the fireproof storage box to this, the trustee manual and the patent beneficiary manual, the FERPA package, and then you get some seminar transcripts, audiobooks. If you want to listen to us instead of watch this again, we'll have a way for you to do that. Finally, we've got our gold version of the wealth protection and preservation program. It's everything in the other, plus we're going to have a monthly coaching call. Gee, you have questions about how to put something into a trust. You have questions about how to avoid estate tax. We're going to go over all of these in a monthly coaching program to make sure that your estate plan is going to do the ultimate most that it can. That's another $298 a month. So, and with that last one, I'm really excited that, I've been told you should offer a guarantee from just a good customer service standpoint. And it's really hard for us to say we can offer a good guarantee, but with this one, I'm happy to say, if there's a change in law that we can draft around, we will fix your plan at no cost to you. So if Congress passes some new text, we're going to fix your plan. If Massachusetts lowers its estate tax exemption, we're going to fix your plan. And I think this is a really good added value to consider. I hope you'll think about doing one of these protection programs. You've invested a lot of money in your estate plan. You want to make sure that you're going to get all the benefits you can out of it. One of these programs is probably going to help you get that peace of mind, so consider any of those. As you've probably heard me say ad nauseum, my web team, my SEO team is like, will you please get more reviews? For those of you who have given us one, thank you very much. We are slowly improving and getting more and more numbers. We need to really hit 100 to be outshining all of our competition here. We probably, if each of you could give us one just to review the seminar, that would help us out an awful lot. So you can scan that QR code. It'll bring you to our Google review page. Take just a second. I hope you'll consider giving us a 5-star review. And then if you do that, maybe just a few words. I will answer every single review. I am grateful for your time and trouble in doing this. It will help us to get more people to be able to find us online. So with that, Whitney and I are available for any questions after this. I want to thank everyone for your time and attention. Yes, Peter?
The slides gonna be made available?
Yes, the slides will be made available. We're going to do that with all of the presentations that we've done this summer. We'll make them all available to everybody. We've recorded most of the seminars, so we're hopefully going to have those online in the not too distant future. Again, I want to thank everybody for coming today. Great questions. I hope it was really informative. We look forward to helping you with all of your estate planning and estate settlement needs. If you have any questions, just let us know. Thanks, everybody. Have a great day.